Greetings! Welcome to episode 5 of our Courts and Trials series. This episode is going to be the last of our 3 parts on the court actors. We've looked at defense attorneys and prosecutors. Today we look at judges. Judges are considered or perceived by most people as the most powerful figures in the courthouse, but as we demonstrated in episode 4, I would argue that prosecutors have that power, and judges are, in fact, when it comes to the day-to-day work of the court, perhaps the least consequential figures, even though that they are the ones who decide the ultimate sentence and must approve all plea agreements. They generally know very little about the case and are focused more on simply processing the large number of cases that they confront on a daily basis. As we begin thinking about judges, we have to think about 3 really important questions. The first is, what is it that we want judges to do? For the most part, we want judges to resolve cases. We want judges to make sure that the process is followed properly. We want to make sure that the judges are fair to both sides. We want judges to make the difficult calls when the 2 sides can't seem to agree. And so then that raises those questions of what characteristics do judges need in order to be able to do those things. Most people would say they need to have some sort of experience. They need to have some sort of legal training. They need to be fair. They need to be just. They need to be open-minded. They can't be biased towards one side or the other. They need to be hardworking. They need to be pretty smart. They need to understand how the law works. And with this long list of characteristics, we have to then begin to ask our third question. How do we get people with those characteristics? How do we find people who are going to be good judges? And so that raises our question of selection methods. How do we end up picking our judges? How does someone get on the bench to be able to wear the robe and make these really challenging decisions on a day-to-day basis? And we find that there's actually 3 different methods that are used throughout the United States. The most common method is election. We're going to vote for our judges, and those judges are going to be then sitting on the bench. Judges will run for re-election periodically. And this occurs in all 3 levels of our court, whether it's the trial court, whether it's the intermediate court of appeals, or whether it is the state Supreme Court. Different states are going to allow judges to be elected to those positions. Our second method is appointment, and this is the way it works in federal court. It's the way it works in several states as well, that the president or the governor is going to appoint the judge and place the judge on the bench, subject to the consent of the legislature. In the United States, at the federal level, it's the U.S. Senate that has to confirm federal judges. And this is the same whether we're talking about the trial court level, the intermediate court level, or even the U.S. Supreme Court. Now, the amount of attention paid to a U.S. Supreme Court appointment is a lot greater than it is to a district court or a trial court appointment. Neither of these methods, though, are entirely satisfactory in that they rely on the political process. It doesn't take much to hear news stories about the U.S. Supreme Court right now and the 5-4 divide between conservative and liberal judges, or the fact that partisan politics play a role in judicial elections. There was a desire to get away from that, and so the state of Missouri came up with what was called the nonpartisan selection method. And basically what this means is that whenever a judge position opens up, there is a committee of people that takes applications for judges. And they will interview the candidates. They will attempt to find whether they have the skills necessary to become good judges. That commission is made up both of practicing attorneys and private citizens. Those attorneys and citizens will discuss. They'll identify 3 different people they think would be qualified to fill that judge position. Those names are then sent to the governor. The governor is required to pick one of those 3 people. Once that person is selected, they will serve for a short period of time and then be up for a retention election. If the citizens elect that person, then they remain in office. It's not contested. The citizenship, the voters simply decide yes or no on that particular judge. And then after the judge is voted to be retained, they serve, again, a certain period of time in which then they face a retention election again. If the public decides not to reappoint that judge, then we start the process all over again with the committee selecting 3 nominees and sending it to the governor for selection. So from these methods, all of them have their positives and detriments. Some of them will be more politically influenced out in the open. Others will be politically influenced behind closed doors. Some of them require bipartisanship. Some of them do not. Some of them will, in some instances, get high-quality people. In other circumstances, you may not. We have yet to come up with an ideal judicial selection method. So with that, let's turn to what it is these judges are going to do on a day-to-day basis. They have 2 main functions. The first is to simply process cases. Judges, especially if you watch court for any length of time, you're going to see are basically involved with processing cases, making sure that they move through the system. The second thing that they're going to do, and that goes along with processing cases, but is they ultimately have to decide the sentence in the case. Judges receive information from a variety of sources, and then they decide what the appropriate sentence is in any given case. So let's look at processing cases first. We have 2 different docketing systems or scheduling systems that courts may employ, and different courts in different jurisdictions employ these different systems. The first is what we're going to call a centralized docketing system. And this is where the case comes from the court of limited jurisdiction. It will be assigned to a single judge in the trial court level. And that judge then will be responsible for all the pretrial matters of the case. So they'll look at change of venue, they will look at joinder and severance, they'll look at bond reduction, they'll deal with discovery matters. All of these different preliminary matters will be handled by a single judge in this particular court. Then as the case gets ready for trial and is at the stage where it is set for either a guilty plea or a trial, that centralized judge is going to send it to a particular judge for resolution. So there may be 6 or 7 other criminal judges in a urban jurisdiction, and those cases then will be spread out among those judges, and that judge is going to be responsible for either taking the guilty plea or trying the case. And once that judge has finished with that case, they go back to the central judge and they say, we're ready for the next case. This allows judges to move cases relatively quickly, but it also allows judges who don't want to work as much the opportunity to sort of hide. They simply don't call back to the centralized docket and say, hey, we're done with what we're doing, send us some more. They can say, look, we've done what we needed to for the week. We're going to take the rest of the week off. It also gives defense attorneys the opportunity to forum shop or pick the judge that they like. If you are the defense attorney and you get sent to a judge that is more strict or more severe in sentencing, you may go to that judge and say, Judge, we're not really ready yet to enter a guilty plea. We're not ready yet for trial, or I have to be in another jurisdiction, Judge. Can I send this back to the centralized judge and then maybe continue it to another week? That judge, depending on the judge's personality, may say, sure, that's no problem. They send it back, and now the defense attorney is happy because the defense attorney is going to have an easier judge the next time around, and they didn't have to waste a change of judge request. This centralized system contrasts with the individualized docketing system. In this setup, after the court of limited jurisdiction, the cases spread out amongst all the judges in that jurisdiction, And that judge that gets the case is going to handle it from beginning to end. They'll handle all the pretrial matters. They're going to handle all the trial matters. They're going to take the guilty plea. They're going to deal with probation revocations. That is their case for as long as it exists. This requires that prosecutors be assigned to particular courtrooms, and they will handle every single case that goes through that particular courtroom. This allows the judges and the prosecutors to get to know each other very well, to the point where the prosecutors are able to predict what the judges are going to do in any particular case. This then leaves the defense attorney sort of sitting out in the cold as the outsider in the courtroom. This also places a lot more responsibility on the individual judge. That judge is going to have to be responsible for managing their docket. If they don't move cases along, they're quickly going to get flooded with cases because cases continue to come in through the court of limited jurisdiction, and if the judge isn't sending them out the other side, the judge quickly gets overwhelmed. And so this requires quite a bit of judicial management, judicial administration skills on the part of the individual judge. And so, again, these two systems, again, have their positives, they have their negatives. It depends on which system you prefer. Next, we need to look at what judges do to resolve these cases. And for the most part, what that means is getting to the point of a guilty plea. And we've talked a lot about that throughout these previous episodes. Today is a day we get to actually look at and say, this is what a guilty plea is. We can have two different types of guilty pleas. We can have one that is called pursuant to an agreement with the state. We can have one that is not pursuant to an agreement with the state. And the difference is simply, did the defense attorney and the prosecutor agree on the outcome of the case? If they did, it is pursuant to a recommendation from the prosecutor, and the sentence has been worked out in advance, subject to the judge's approval. If it is non-pursuant, then there is no agreement, and the defendant is simply pleading blind or open to the court, asking the court to impose a sentence that is acceptable to the defense. The prosecutor then has the opportunity to argue for what the prosecutor believes is an acceptable sentence. And in these circumstances, the judge does have to decide what the appropriate sentence is going to be. In order to accept a guilty plea, there are certain legal requirements that are necessary. All guilty pleas, according to the U.S. Supreme Court, must be done knowingly, voluntarily, and intelligently. What does that mean? Well, first off, with knowingly, the defendant has to be aware that they are entering a guilty plea. They have to be aware that they are giving up certain rights when they enter this guilty plea. What do we mean by that? Well, they have to know they're giving up their right to trial. They have to know they're giving up their right to jury. They're giving up their right to confront witnesses. They're giving up their right to remain silent. They're giving up their right to a presumption of innocence. Right? All of these different rights are being given up, and they have to be aware that they're giving up these rights. It must be done voluntarily. It can't be done under coercion. They can't be, threatening someone's family member or threatening their life to get them to plead guilty. It also has to be done free of influence of any controlled substance or alcohol or mental illness. They have to understand the process that they are going through. Finally, it must be done intelligently. It must be done in order to, there must be facts sufficient to support the criminal charge. In a murder case, it means you need to have evidence that the defendant intentionally, with premeditation, killed somebody else. We're not going to allow someone to plead guilty if the facts do not justify the charge. And this is all done through a series of questions and answers. So if you go and watch a guilty plea, you're going to hear the judge ask lots of questions of the defendant regarding these different rights, these different facts, and whether the plea is done voluntarily or not. Once the plea has been accepted, there is a range of sentencing options from very minimal to the very severe. First off, we can simply sentence a person to jail. That means they're going to be in a facility that is controlled by the local jurisdiction where the defendant lives. So if you are in a particular town, you're going to go to the city jail. Odds are that's where you spent your time prior to the case being resolved. The longest you can be sentenced to jail is up to a year. If it's more than a year, then you are sent to prison. The difference between jail and prison is that jail is a locally controlled facility. Prison is a state-controlled facility. And odds are you're going to be sent somewhere much further away from your home if you are sent to prison. Generally in prison, you're going to be sent there for a term of years, from 1 year all the way up to life in prison. If the judge doesn't want to incarcerate the person, one option is to simply impose a fine. This is some sort of monetary penalty that is paid to the court. It does not go to the victim. It is not restitution. You can't give someone a $500 fine and say that gets paid to the victim. Restitution happens through a different process. Finally, on the other extreme, if it is a murder case, then in some states the death penalty is an option as well. Now, all of these different sentences, whether it's jail, prison, fine, even death, can have the execution of the sentence suspended. What does this mean? Basically, it means we're going to place the person on probation and not send them to prison for 5 years, 6 years, 10 years, life. We're going to suspend the execution of sentence and instead place the person on probation. So it's important to understand probation itself is not a sentence. It is simply the conditions under which the person has their sentence suspended. And if you are placed on probation, you must fulfill certain obligations, such as not committing any more crimes, not using any controlled substances, not associating with any felons, reporting to a probation officer, maintaining a residence in the jurisdiction where the crime occurred, getting a job. Some judges even go as far as requiring a person to get a library card or read a book or get a high school education. Different conditions can be imposed. If the defendant doesn't like those conditions, the defendant can simply go to prison instead. Beyond all of this, the judge could even step back a bit and say, look, I'm not even going to impose a sentence. I'm going to suspend imposition of sentence so that instead of me sentencing you to 3 years and suspending the execution, I'm not even going to impose those 3 years. I'm simply going to wait and I'll place you on probation. Probation would work the same way under the suspended imposition of sentence as it would in the suspended execution of sentence. You have a probation officer, you have to report it, you have to abide by all these conditions. There's two key differences with the suspended imposition of sentence, though. With the suspended imposition of sentence, if you violate probation, rather than getting the term of years you were sentenced to, you could be sentenced to any amount of years within the range of punishment. So if the range of punishment was 1 year to 7 years, and you had a suspended imposition of sentence, you could get up to 7 years of prison. Whereas a suspended execution of sentence, if you were sentenced to 3 years and that was suspended, then you would get that 3-year sentence. The other big benefit of a suspended imposition of sentence is that you can say, because no sentence was ever imposed, you were never actually convicted of the felony offense. That allows you, when you go to apply for a job, to honestly say you have no prior felony convictions on your record. And oftentimes that can make the difference between being hired or not. All of these, though, no matter what the sentence is very difficult for a judge. Research has shown us that judges dislike the sentencing aspect of their job the most simply because it is so challenging. Trying to figure out what is the proper punishment for a given set of facts, especially when you don't know much about the case. All judges know about a case is the indictment and then what the prosecutor and defense tell the judge about the case. And of course, the prosecutor and defense are telling very different stories about that case. We'll talk more about stories when we get to the trial stage, but we're going to find out that what judges really do or try to decide between these two different stories. So as you can see, judges play a very important role, but they do it under very limited circumstances. So this wraps up our three-part look at the court actors between defense attorneys, prosecutors, and judges. Episode 6 will get us into the pretrial stage.